Right. My name is Ben Yong. I'm an associate professor of public law at Durham University, and I'll be chairing this discussion about contempts and select committee powers. And it's being held under the kind of auspices of the Study of Parliament group. So there have been a number of high-profile cases where a number of individuals have refused to appear or threatened to appear before a select committee, even after being summoned by a select committee. And a couple have been held in contempt of House. And the question really arises, well, what can Parliament do? There's admonishment, of course, but in theory, Parliament could also fine or imprison them. But there's a real question about whether or not this power, the sort of penal jurisdiction of Parliament, continues to exist, whether it complies with modern day human rights law, and under what conditions this power could be exercised. And the Commons Privileges Committee released a report a couple of months ago examining the options open to Parliament and recommended legislating for a new statutory regime. And it even provided a draft bill which makes failure to comply with the summons from a select committee a criminal offence. It's called for submissions to that report, and it's that report and its recommendations which we're going to discuss. And we're very lucky to have with us tonight three distinguished discussants. First of all, Chris Bryant MP, who is the Privilege Committee Chair. He's a staunch defender of Parliament, an advocate of restoration and renewal of the Palace of Westminster. He was chair of the Finance Committee, which is responsible for advising the House of Commons Commission about the budget of Parliament. And he's written a biography of Parliament, a two-volume biography. We've got Alex Horne, who is the former legal advisor to the House of Lords EU Committee, currently a counsel with Hackett and Dabbs, which is a law firm which deals with public law issues and human rights issues. He's also an advisor to the International Agreements Committee in the Lords, and a visiting professor at Durham University. Last, but certainly not least, Elise Bertoubise-Lauranger, sorry if I mangled your name, who is Senior Parliamentary Counsel to the Senate of Canada. And just to be clear, that means that she works for the Senate in the federal parliament. She's not Parliamentary Counsel in the UK sense. And she's also the former president of the Canadian SPG. And we're hoping that she'll give us a bit of a comparative perspective. Okay, just to say a couple of things on the format. So I'll be chatting with our discussants for about 30 minutes. That will be recorded. It is being recorded. Then we'll move on to the Q&A. That won't be recorded. It will be subject to the Chatham House rule. If members of the audience could mute themselves and refrain from using the chat function during the kind of discussion, that would be good. But you can use the chat function once the Q&A starts. The other thing to mention is that the Privileges Committee is still taking evidence submissions that will respond to the committee's report and recommendations. So if you feel inspired by this discussion, which I'm sure you will, then please do send them something, your view. And the committee will be taking further evidence after conference recess. Okay, so I will get started. Chris, do you think you could briefly take us through the options and the reasoning of the Privileges Committee and why the committee decided in favour of legislating for new powers?
Sure. So first of all, it's worth remembering that the Privileges Committee in Parliament can only investigate anything if the House has asked it to do so. And the House asked it to do so several years ago, long before I became the chair of the committee. And we've never managed to come up with a final report until in this Parliament. And the reason that Parliament wanted us to do so was because there'd been a significant number of high-profile cases of witnesses either refusing to attend or being so recalcitrant that by the time they did end up attending, the moment had passed, so the committee didn't then want them anymore. We also noted that increasingly witnesses who are not particularly keen on attending a select committee hearing are being given legal advice that the Commons has no power to insist. You referred earlier to us Parliament having theoretically the power to fine or imprison. I neither think it has nor that it should have the power to fine or imprison. I think that would be a complete contravention of of all the advances that we've made in human rights and legislation, and it would be rather akin to the medieval acts of attainder, which I think would not be an appropriate way of us proceeding today. So I don't think we can fine, I don't think we can imprison, and that's been the decision of several previous committees that have looked into this, including a Royal Commission. Everybody's always identified the three positions one could adopt in relation to this. One is do nothing and just live with it and go, oh, well, there we are, let's all shrug our shoulders. I think most MPs now think that will be inappropriate because it is a growing problem. Because in the end, an individual who doesn't want to attend is probably simply balancing the reputational risk of attending versus the reputational risk of not attending. And simply being admonished doesn't seem to bother anybody. The second route that we could go down, or people have suggested that we could go down, is simply we restate our old powers through our standing orders. Unfortunately, I don't think that answers, and not a single person gave evidence to suggest that would answer the problem. If anything, it would simply give the impression that the House of Commons still thinks it has powers which it hasn't got, and would basically bring Parliament yet again into further disrepute. And so that leaves us with legislation. Now, I understand, and we all understood on the committee, that legislation is always dangerous in this territory, though we note that lots of other administrations around the world have some form of criminal offence, including several Commonwealth countries. We'll hear about Canada in a few moments and some of the issues that they've been having, but Ireland, New Zealand, Australia, and Canada, and so on, and of course the United States of America, though it's not in the Commonwealth. But parliamentary systems where they have some form of either criminal or civil offence of refusing to come and give evidence. We wanted to do, and I understand the concern that some people have, which is that Article 9 of the Bill of Rights, of course, guarantees that no proceeding in Parliament shall be impeached or questioned in any court of law or any other place. And we want to minimise the chances of the court, of a court at any point seeking to question or impeach a proceeding in Parliament. But we also want to make sure that witnesses attend, and that if they refuse to attend, then that there can be some means of punishment. But we don't think that punishment should be inflicted by a parliamentary process. That should only be inflicted by a court process. That would, I think, be consonant with both the Human Rights Act and with the European Convention on Human Rights. And then and that's why what we've tried to draw up is a system whereby the decisions that are taken by Parliament in a proceeding in Parliament are clear. They guarantee for potential witnesses that how they will be treated, and that there will be due process about the decision that is taken by, first of all, the individual committee, and then by a gatekeeper, possibly the Committee on Privileges, and then by the Speaker. And we're using the honoured system that's been around since 1911 of a Speaker's certificate to be able to determine whether somebody had failed to attend. And then then the decisions on how to deal with that are left to the court, including whatever sentence they might want to hand down. I'll just end with one final point, which is that I know there are people, and indeed some on the committee, who think that select committees should only be able to look at, to scrutinise government ministers. So a select committee should not really be able to bring in, the captains of industry or even somebody who runs the Bank of England. They should only be able to focus on government decisions. I think that flies in the face of parliamentary history in the UK. If you look at nearly all the advances in the 19th century, they were on the back of select committee hearings who had all sorts of people come in to give evidence. Nobody ever said no. And it's only in the 21st century that we've seen this advent of people refusing to come. And I actually think, as a constituency MP, my constituents are as interested in pursuing the rights and in seeking redress for their grievances, whether that is by the post office, the Royal Mail, the ASDA, Sainsbury's, or any other major player, or for that matter, Facebook and Apple. So with those comments, that's kind of where we're at and where we've left it. I should say at the start of the process, half the committee were opposed to legislation, and by the end, the whole of the committee were in favour.
Right. Thanks, Chris. Elise, what's the situation in Canada?
Well, the power of both houses to punish for contempt was inherited from the UK House of Commons back at Confederation, so 1867. The Constitution Act of 1867 recognizes that the House of Commons in Canada and the Senate are basically inheriting the privilege of the UK Commons. So is similar to the power enjoyed by the House of Commons at the moment. Punishment for contempt in Canada can range from a simple finding of contempt with no further action. It can also mean censure, reprimand, admonishment. These are not things that are used very often, but we do have them. The contempt power, but I think it's fair to say that the contempt power and possible sanctions has not evolved a lot. It has remained pretty static since Confederation, with one notable exception that was raised already today, which is the power to incarcerate. So obviously that has not been used recently. The last detention in the Parliament buildings happened in 1967. So I'm not going to qualify that as modern by our standards, and therefore has likely lapsed. The other important element to consider when we're looking at the power to incarcerate would be the adoption of the Canadian Charter of Rights and Freedom in 1982. That constitutional document brought into the Constitution some procedural fairness guarantees, such as the right to a fair trial, the right not to be held without knowing what you're charged with, things like that. So it is unlikely that the power to incarcerate would be upheld should there be a charter challenge on that question. Now, the current discourse in Canada is very much between the tension between those contempt powers, those sanctions, and the rights and privileges, the rights that are guaranteed under the Charter. That's where the discussion is happening. We've had a few studies in Parliament about this, but no actual recommendations were put forward, meaning that it has kind of remained the status quo, and we don't really have a clear indication of how those two things work together. We did have some activity in this department in the last few months. There was a situation involving a special committee on China-Canada relations, where the committee was seeking documents that were held by the Public Health Agency of Canada. The documents were obviously sensitive in nature, and the Public Health Agency refused two committee orders to produce unredacted documents that were to be deposited with the law clerk at the House of Commons. With that call from the committee being unanswered, this eventually went to the House, and the House adopted an order that the Public Health Agency was in contempt of Parliament. The head of the agency was called before the House for an admonishment, and also was requested to deposit the papers that were being asked by the House in the committee orders. he did show up. He was admonished. He did not bring the papers. So that continued on. And then a little bit of a surprise twist in all of this was that the government of Canada filed a lawsuit, not a lawsuit, a court action, I should say, in the Federal Court of Canada, basically saying that under the Canada Evidence Act that they would not be able to provide or comply with the order of the House. We have a few provisions in the Canada Evidence Act that basically say that if the government believes that information that could be released in a proceeding could be sensitive to the point of national security, that information can be to some extent withheld, or that we go to the court to tell us how to manage that information, that evidence, in the context of the proceedings. What the government forgot to perhaps look into was the fact that the parliamentary proceedings were very much excluded from the concept of proceedings under the Canada Evidence Act. That happened in the parliamentary debates when the original draft of the bill that was before Parliament had included Parliament, and that was eventually taken out of the bill. So there was a clear intent not to apply that portion of the Act to parliamentary proceedings. So the position of the House of Commons in this court case was to say, basically, this is an exercise, it's a valid exercise of privilege, of a privilege that has been established of the House to call for papers, and that the court has no jurisdiction to render a decision on this matter. So that was all very interesting for all of us parliamentary nerds that are looking at these questions. However, the Canadian Parliament was dissolved in August for a general election, and the case has since been withdrawn. So we will never know how parliamentary privilege and the Canada Evidence Act work together. Perhaps too, it's a comment on the government that they may not have thought of everything before filing that court application. So that's the state of things in Canada for now on that question.
Can I just take you back to, there's a little point about something that Chris said, that in a way, yes, select committees are there to scrutinize the executive, and that's their primary role, but they also now have a bigger role where they can examine the work of private individuals or corporations, because they also affect their constituents. And I wondered if you saw in Canada this kind of new development in Canadian select committees.
Sure. So on that question, I would say that is an established practice in Canada, and not a controversial one. There may be diverging views on this, but that is my personal experience in the last, I guess, 16 years now on Parliament Hill, is that parliamentary committees do take on studies that go much further than just scrutinizing the activities of government. There are many examples of this, and even some studies go beyond what would be considered federal jurisdiction. So to point to a few examples, we have official languages committees in both houses, and the House committee recently looked at early childhood education in Western Canada. So this is something that is completely provincial jurisdiction. Obviously, the federal government does transfer money to the provinces for that, but it is inherently a provincial matter. So they looked at that, and it's also usually privately owned. These childhood education centers are privately owned. So they are subsidized by the state, but not completely funded by them. The House Environment Committee has looked at plastic use in Canada. So, sort of looking at that industry and the players in that industry, the producers of plastic, the users of plastic. That is, again, beyond, oversight of the government. We're looking at a specific industry. And my favorite, the Ethics Committee on the House of Commons side, I used to work for that committee as a legal analyst at the beginning of my career, and they don't limit themselves to to their mandate either from time to time. And they've looked at things like Google's Street View when that technology first appeared and the privacy concerns surrounding that. They've invited Facebook to appear on a number of different issues. So there's lots of examples of the industry being examined by parliamentary committees, and it's not something that is inherently problematic. Where we get into some trouble, I think, is when there's no actual policy anchor to support the study. So if we're looking at something that is overtly partisan, or that is outside the scope of the mandate of the committee or the topic of the committee, that's where witnesses start to think, okay, this is not for actual policy issues. I'm being called for partisan reasons and partisan reasons alone.
Right.
And that's where we get reluctance from witnesses to appear. And we have a recent example with the We charity that this happened this year. There's big controversy about that charity in Canada. It was linked to the Prime Minister and to the Finance Minister, and the Ethics Committee invited the founders and presidents of the We charity to appear before the committee. They had appeared previously before a number of different committees, including the Finance Committee. I think they were getting a little tired of being dragged before parliamentary committees, and they refused to appear. Eventually, they did agree, but their first response was to say, no, the Ethics Committee would just basically be for partisan reasons. We've already said what we had to say. So that's where we get reluctance, I think, from witnesses more than, so I think that's more the issue than the actual role of committees of looking that are broader than government.
Alex, so you've been quite critical of the Privileges Committee report and its recommendations. I think one of your criticisms is that really the primary responsibility of committees is that they should focus on scrutinizing the government. Did you want to talk about some of your criticisms?
Sure. Well, let's start with first principles. And I mean, I think if we take Parliament, I think the primary purpose of Parliament is to legislate and to hold the government to account. When you look at the points that Chris made at the beginning, there were some reasonable ones there, but I suppose it depends what you constitute as the government. So some of the examples that he gave, like the Bank of England, well, members of the Monetary Policy Committee of the Bank of England are already subject to confirmation-style hearings by Parliament. I think when we talk about the government, we can be quite wide-ranging here, and we can include regulated industries and the regulators that regulate them. That's all fine. I think Elise touched on the problem, and it's that Parliament's not there to be a court of public opinion. This sort of thing first started, I think, during the banking crisis. I remember being sat and watching the TV, and I think it was Harriet Harman turned up on one of those shows like Frost or Mar, I can't remember who was in charge then, and started talking about his pension. And said, well, we won't have this, as though somehow, Parliament was going to seize the money from him. And you began to see more and more of this, I think, where Chris referred to them as sort of captains of industry, but essentially people doing things that were unpopular began to be summoned. There was a notorious example with Kraft, where they purchased Cadbury, and kept getting requests that the chief executive of Kraft come and attend Parliament, despite the fact he was based in America, and whoever else was sent in his place wasn't accepted, and various letters started emanating from the committee making demands. You saw demands about Facebook, you saw demands about all manner of other unpopular characters. And I think essentially it's a sideshow. It's a sideshow. Most of these industries are regulated. Where the problems lie, the regulators should be brought in and asked why are their failings. And these individuals can be asked to come in as well. I've got no problem with that at all. It's this idea of compelling them to come in and essentially trying to hold something resembling a trial or some other court-based process in Parliament, as though Parliament is a good place to hold investigations of that sort. And bluntly, it's not. The protections aren't there. These people are not going to come in with their lawyers. We can make comparisons, but when you look at the US Senate and you look at the way those hearings are run, they're very legally based. Parliament is not set up with a whole host of lawyers with each committee. There's a small bunch of lawyers in the House of Commons, and even a smaller bunch of lawyers in the House of Lords. and their days are not spent advising committees on how to give witnesses fair treatment so that processes, would meet the relevant standards. I mean, the one thing I would say, just in terms of the context of this, which we haven't explored, this is the third report in not that long on these issues. There was one in 1999 by a joint committee. There was another one in 2013, again by a joint committee. Both of those had the merits of looking at privilege as a whole. The draft bill, only focuses on one very narrow area, which is essentially compelling people to come, handing over documents and punishing them if they don't. There's no reference in the draft bill to protections for witnesses. There's no reference in the draft bill to any of the other issues around privilege that have caused difficulties in the past. I can see that there's a narrow issue that the committee would like to deal with, but I think many people think this ought to be dealt with in the round if you begin to legislate on privilege, and perhaps have a Privileges Act instead. And lastly, if there's time, I just pick up on some examples of areas where I would be concerned, because it's not just the fact that these characters are not always sympathetic and you wonder what treatment they would get from Parliament, but when Parliament has tried to use the powers it already has, it's not always done so in a fair way. And I'll give you three examples. The first is the example where Margaret Hodge and the Public Accounts Committee had in a senior lawyer from HMRC, put him on oath in front of the committee, a point that was criticised subsequently by the House, Anthony Inglese, and tried not to recognise two fundamental concepts: taxpayer confidentiality and legal professional privilege, asserting that the powers of the House somehow overrode all of that. Now that shows two things. It shows a misrepresentation of the power. It also shows the problems when you don't have lawyers in place to advise on the consequences of all of that. Because had Inglese actually handed over that information, he probably would have been in difficulties with his employer, but also with his profession. And you then would have been somehow trying to rely on parliamentary privilege to allow for breach of legal professional privilege, something which is problematic. The second example I'd give is Facebook and the ridiculous antics of the DCMS committee in sending the Sergeant at Arms to go and obtain information, allegedly seizing the information, although it subsequently became clear that the person handing it over was using this process in order to try and thwart court proceedings in the US. And I mean, the whole thing was very disreputable as far as I could tell, and looked like a complete farrago. There was a third example that involved Keith Vaz, but I mean, it's before the watershed, it's Keith Vaz, and he's left the building. So let's pause there.
Okay, thank you, Alex. Chris, do you want to have a quick rejoinder at all? Because I want to ask two more questions and then we should open it up to questions and answers. Just briefly, if you could.
Well, yes, sure. I just think Alex's understanding of Parliament is fatally flawed in nearly every regard. We've been able to have witnesses give evidence on oath ever since the Parliamentary Oaths Act. The role of Parliament is not just to legislate and scrutinise government. That's a very high Tory view of it. It's to govern. It's to provide supply to government. It's to redress grievances. That's where all original legislation came from. And I think that's why it's vitally important that we're able to bring in anybody in any of the regulated industries, which basically means every single industry in the UK. It is also to legislate. And frankly, yes, of course, it's a court of public opinion. That's exactly what it is. A court of public opinion.
Right. So a couple of days ago, the House of Lords published a letter saying they do not agree with the Privileges Committee. And so I'm wondering, what now are the realistic prospects for legislating in this area? Chris?
Well, I mean, whether we end up with, I should answer one other thing about Alex's point, which is we as the Privileges Committee can only consider that, he should know this, we can only consider those things which we are asked to consider by the House. And that's one of the, I think, the flaws in the way the Privileges Committee is set up in the UK, but that's the way it is. And that's why we've combined ourselves to a small area. We haven't put the treatment of witnesses in as part of the legislation, because that would very definitely be to bring proceedings of Parliament into the ambit of justiciability in the courts. But we did say quite a lot about how witnesses should be treated, and that we probably need a better and clearer set of expectations from for committee chairs and for members of committees when they are interviewing witnesses. I've forgotten what the letter from the Lords and whether we'll end up with legislation. I don't think the Lords is the issue. The issue is, and incidentally, the Lords letter I thought was the thinnest gruel I've ever seen from a consideration of a report. I mean, it doesn't say anything about why they disagree with the report. It just says they disagree with it in a rather high-handed, lordly way. The key thing, I think, is whether the government thinks that there should be legislation, because in the end, in our system, it's only if the government is going to introduce a bill that we'll get anywhere. We've tried to present two possible options, and we hope that the House will come to, and we're still listening to people as to whether they think either of those will work. There are some who favour the contempt of courts kind of process, because they think that that is a clearer way of keeping the courts out of proceedings in Parliament. There are others who think that the criminal offence process works better. But I just point to the fact that most countries around the world have some system of enforcing their powers. And this is not about giving us new powers. This is simply about how do we make historic powers work in the modern era.
I think the Lord said that the reason they weren't in favour was because they were worried about the courts getting involved. Alex, do you think this proposed legislation has any chance now in Parliament?
Bluntly, probably not. I mean, I was surprised at the outset that, given both previous processes were conducted jointly, that this process was conducted in the Commons. You can see the problems with the draft legislation and the proposals. And admittedly, the committee posed this as questions subsequently, but you end up with all sorts of questions from the drafting of this. First of all, it defines individuals complying with summons. Does that include peers? Does that include MPs? Does that include ministers? I think the answer to that question is probably not. And that exposes the ridiculous nature of this bill and this proposal, that essentially you have a proposal which suggests that private individuals can be summoned to Parliament, and that if they refuse to come, they can be not only admonished for that, but can possibly be imprisoned. And on the other hand, ministers who are meant to be accountable to Parliament are probably not included. At least that's the understanding I have of the current drafting of the bill. I think if ministers and civil servants were directly included in the scope of this bill, and the Osmotherly rules, which many people here will understand, but which, if I need to explain, essentially mean that on some occasions ministers will stand in for civil servants, and that the government does not accept that individual civil servants might necessarily be summoned. If those are to be suspended by this legislation, I see no chance of the government supporting it at all. The letter from the Lords makes an interesting point, which is that the Lords actually says that they are concerned about the willingness of some ministers to appear before the House. And I think the priority, if you're looking at where select committees should be focusing their attention, is the type of ministers that attend and the type of evidence that they're able to give, whether or not they can get senior civil servants in where there are issues of accountability there. And last of all, which I think Jonathan Jones, the former Treasury solicitor, picked up, the sort of standards that are applied to fair treatment of witnesses, which have been discussed before many times, but have never really been formalised in a particularly good way.
Why not?
I think if I was looking at that, those would be the sorts of things that I would have been interested in touching on.
Why not, Alex?
Why?
Why hasn't there been a comprehensive set of principles about fair treatment of witnesses set out by the houses? I mean,
Well,
I know
the
the
2013 report,
2013.
yeah, that looked into it,
Yeah.
and as far as I'm aware, and I'm sure we have people in the audience who can tell us, dealt with those issues. We simply haven't seen it sort of brought forward with clarity. Now, I mean, the other reason I suspect that the Lords have written this letter is that I suspect that the Lords have had far fewer problems getting witnesses to attend, because, to be perfectly frank, the behaviour of their committees tends to be rather more respectful to witnesses and rather more sort of an approach to get evidence rather than sometimes to play theatre. And playing theatre is fine, but it's no surprise that some people don't want to turn up in that context.
Right, I'm going to quickly end this with one question to Elise. And it's a bit unfair to ask you, but what if this bill came before the Canadian Parliament? What do you think? And just a brief secondary question, what kind of rules do you have in place for the fair treatment of witnesses?
I'll start with your first question. If this bill came before our parliament, I think one of the reasons we've never actually codified anything is that we would struggle tremendously with agreeing on language. And so if there was a fully written bill, you know, it would take some time to study it and go through all the potential ramifications. The other thing, I think with the way your bill is currently drafted, the proposal, we would probably have some charter challenges. As I mentioned earlier, our procedural fairness in penal matters are all constitutionalized in Canada, and so is privileged, and so we would probably have some concerns about the way that some of these, because if I understand it correctly, the parliamentary process would determine whether or not there's contempt, and then it would go to the court for the enforcement portion. And so with that determination in Parliament and the fairness, that would the requirements would be quite high, and I think that there may be some concerns about that from our charter and our constitutional point of view. Now I'm blanking on your second question.
The question was whether or not you actually had a kind of some
procedural fairness for witnesses. No, and I think that that's a problem. And I would even extend that not just to witnesses, but also to officials who are not often treated fairly when being questioned in Parliament. That is something that many of us on this call have probably faced as officials being called before a committee to explain some things or to provide updates on files and things like that. Where sometimes
why not? Why haven't you got these? I mean, I would feel this being quite.
It's a good question. I don't know that there have been recommendations to look at this further, and there's never any particular interest in actually getting that work done. I'm not sure what to attribute this to. I know that, I mean, from our very unique perspective in the Senate has been quite busy in the last few years. So perhaps there was bigger fish to fry in that sense. But I don't think the fair treatment, we don't have protection for fair treatment. And whether that could be done, I think so. I think that could be done internally in Parliament. One of the recommendations from 2019 was to look at what is being done for judges. So the Canadian Judicial Council has a complaint mechanism against judges. Well, if we can do that for judges, there's a good chance we could do that in Parliament as well. When there is unfair treatment, would there be a mechanism in Parliament to deal with that? So I can't explain exactly why we've never looked at this, but it is a question that has been left without an answer.
Right, thank you. Right, I'm sorry it took so long on this. Let's go to question and answers. So you've got two choices. You can audience members can either put their hand up electronically, I think,